We're taking now live to Parliament as the Special Prosecutor Nominee Kissi Agyebeng takes his seat as he's vetted by the Appointments Committee.
Yes, we administer the oath.
I, Kissi Agyebeng,
solemnly swear that the evidence I shall give before this committee
solemnly swear that the evidence I shall give before this committee
touching the matter in issue shall be the truth,
the whole truth,
and nothing but the truth.
So
help me God.
So help me God.
Mr. William Kissi Agyebeng, on behalf of the committee, I congratulate you on your nomination to the very unenviable position of Special Prosecutor, the second since the office was instituted. We have your CV, but kindly tell us a little more about yourself, those that are relevant to your training, your experience, for the record.
Thank you, Honorable Chair. Good morning, Honorable members. Honorable Chair, I used to be called William, but I dropped it officially a while ago. So my name just remains Kissi Agyebeng.
Well, I've seen that William is on relevant certificates.
Yes.
And so it's important for our record.
Yes,
right?
I designated it on my CV as former name. Right. So I'm Kissi Agyebeng. I was born on the 2nd of July, 1978. I started my primary education at Holy Star Academy at Laboni, in Accra. And then we moved from La to Teshi, and I was enrolled at the Wajel Barracks School to continue with my primary education. And this is at the military barracks at Teshi Camp. So in 1989, together with a few of my colleagues, we tried our hands at the common entrance examination. And I enrolled at Damfa LA Middle Mixed School because at that time I was a bit too young to write a common entrance. But on the first try, I passed and I gained admission to Accra Academy, where I did my secondary education. I spent 7 years in Accra Academy, Form 1 to Upper 6. I took my GCE O-level in 94 and GCE A-level in 1996. From there, we waited 2 years to enter the university. But in the interim, I did my first national service at the Information Services Department at Kissi. In 1998, I gained admission to read law at the University of Ghana, where I graduated in 2001 with a Bachelor of Laws LLB degree, first class honors. And then I proceeded to the Ghana School of Law in 2001. I was called to the bar on 3rd October 2003 after having successfully completed the professional law course. And then I returned to the University of Ghana as a teaching assistant in the law of contract and conflict of laws before my pupillage. And I did my pupillage at Zoe Agyebeng & Co. between 2003 and 2004. I gained admission to read a Master of Laws program in Marine and Environmental Studies at the Shoolidge School of Law at Dalhousie University in Halifax, Nova Scotia, Canada in 2004. I graduated in 2005, and then I also proceeded to read another Master of Laws program, LLM, at the Cornell Law School in Ithaca, New York, in the United States. I then returned home, and I was appointed a lecturer in 2006 at the University of Ghana, Faculty of Law, now School of Law, where I've been teaching the past 15 years to date. Alongside that, I was also building my private practice. I had a few stints at the Center for Public Interest Law, a human rights public interest law firm. I had another stint at the Legal Resources Center, another human rights law firm. And then around about in 2008, 2009, I joined a new law firm that was being formed, Aina and Feli. I was there till 2013. And in 2014, I formed my own law firm with a partner, Cromwell Gray LLP. And I've remained the managing partner to date. I was appointed as the chairman of the Electronic Communications Tribunal in 2019, and I've been the chair till date. Mr. Chairman, Honorable Chairman, in sum, these are the highlights of Kissi Agyebeng.
Let me ask you before I continue. All this while that you were moving from one chamber to another, forming your own chambers, you are still an employee of the...
When our forebears argued successfully that the law court is the laboratory of the lawyer. So the theories we propound in the law classroom should be tested out there for its veracity. So we are allowed to practice and still lecture at the same time.
You mean if the university policy that a lecturer at the law faculty can also engage in private legal practice? I just want those things for
Yes, Honorable Chair.
Very well. Leader should have opened up before he started, but now may take the floor.
Chairman, I should thank you for the opportunity and should join you in congratulating Kissi William Agyebeng, Kissi Agyebeng, Kissi Roland, Kissi William. Chairman, I'm doing it on purpose. I'll soon be asking him after my opening remarks when he dropped the formal or informal name of William for our record. But Chairman, this is just to warm him to, as you describe it, the unenviable position High Office of Special Prosecutor, Ghana needs you. And Ghana will need a person who would fearlessly and courageously fight corruption. So which we are told we lose $3 billion annually to graft and economic related crimes and to fraudulent practices associated with procurement and other unethical conduct in our country. Moral crusades have not helped us. High ethical standards have not helped us. We need persons or a person with a will to support the president and the country to nip corruption, because it has shattered the dreams of many, contributed to joblessness in our country and to poverty in our country. So welcome. But Chairman, when did you drop the William and why?
Formally earlier this year.
So it's just a 2020 drop, a 2021 drop.
It had become redundant for more than 30 years.
But not abandoning formally.
Yes.
Some of your friends.
So I decided to formally drop it.
All right. So, Chairman, to now Kissi Agyebeng, why did you have to drop William?
Honorable Chair, I've just explained that it had become redundant.
What made it redundant? Was that a baptism name?
It was a baptism
name. You
name.
Didn't name yourself. You know that culturally
no,
and
I
religiously.
Didn't. Actually, Honorable Chair, I would have dropped it long ago, but because my father was also called William, so it was an honor to him that I was still keeping it. But after I made my peace
so
with
was
him,
it in dishonor to drop it?
No, Honorable Chair. I made my peace with him that I needed to shake that foreign name from my name and keep my local names.
All right. So, Chairman, just to, I'm happy you stated that you used to teach conflict of the laws and law of contracts. Now, the evidential rule, burden of proof, particularly in criminal jurisprudence, proof beyond reasonable doubt. Do you share the view that we should criminalize unexplained wealth in Ghana? Do you share the view that we should criminalize unexplained wealth in Ghana?
It is a bit too, Honorable Chair, it is a bit too overbroad to state unexplained wealth. In criminal jurisprudence, legal criminal constructs should be more pointed, more focused, and clearly delineated because of the specter of someone ending up in jail, losing his liberty, or being fined heftily for an amount. And so if we are to place it in proper context, unexplained wealth, I would say that if the person cannot reasonably explain as much against his lawful income, the amount of money in question, then that aspect, in my opinion, should be criminalized. But if you can reasonably explain how you came about that amount of money, then that should be allowable, that should be acceptable. So in your context, unexplained wealth would be reasonable explanation of the source of that property, wealth, or funds.
Chairman, just to take the nominee, I appreciate your response to it. If you take the United Kingdom today, where Ghana largely borrowed its legal system, largely, they now, for purposes of combating economic crime and fighting corruption, have what they call a reverse burden of proof, that the onus must shift, that when those assets cannot be explained for, an irrebuttable presumption is that they are acquired illegally, fraudulently, it may be taking advantage of the state and its resources. So they now go for a reverse burden of proof. Will you subscribe to that for Ghana in our quest, our collective quest to fight corruption. Thank you, Chair.
Honorable Chair, I'll link it to my answer to the first question. Also, pointing out that criminal constructs are very, very dangerous if not well thought out. A reverse onus clause, as the honorable member rightly put it, puts the burden on the accused person to explain to explain one way or the other the charge against him, rather than the prosecution bearing the burden of proving his guilt. In the context in which I answered the first question, of course, if the construct here is that you cannot reasonably explain as to how you came by that wealth or property matched against your lawful income, then it presupposes that I have already placed the onus on you to show as to how you came lawfully in possession of that wealth, property, or funds. So in that context, my answer will be yes.
So, Chairman, still there, you have like a public official, maybe at Public Procurement Authority, who has 9 million in his account. And for purposes of accountability, that's why every country that is committed to fighting corruption has asset declaration regimes. And the essence is that you should be able to match incomes, legitimate and lawful, with unexplained wealth. Now you have this 9 million in the account of a public official, and maybe 3-4 years back, that money was not there. It's probably because he's associated with the political authority in power, and his income cannot explain a 9 million in his account. If you were a special prosecutor and that was brought to your attention by an ombudsman in the Republic, what would be your attitude to dealing with this matter? Thank you, Chair.
Honorable Chair, as I stated, it should be matched against your lawful income. And so I'll be looking up in respect of the sources of that income. Perhaps the person in question earns some other income from some other vocation. Maybe he has a cocoa farm somewhere, in a forest area somewhere, and he earns money from it. That would be lawful. So whatever the source of the income is, should be lawful. So the aggregate...
So accepted, Chairman, accepted. So now, is it not a case that the state could say, okay, come and explain to us in the context of the British system how you got this 9 million? That's the reverse burden of proof. The proof beyond reasonable doubt is no longer going to be the onus on the state. But we cannot explain how come you have 9-10 million as public official in your account. And legitimately, there's nobody in Ghana from the president through ministers of state, except those undertaking businesses, who should have that quantum of money. You are to help us fight corruption. Wealth that cannot be explained. We want you to be the lead police in tracking and finding answers to them to save this republic. Can I have your commitment to that? Thank you, Chair.
Honorable Chair, you have my firm commitment. You know, Honorable Chair, corruption is secretive and very, very complex. And most of the time, it transcends national boundaries. And unless the participants of the corrupt activity are opening up to you, it is very, very difficult to, on your own, establish that these funds came about unlawfully. And so, as I keep saying, if I were to place the burden on you, matched against your lawful income, and you cannot reasonably explain the shortfall as to how your lawful income falls short of your wealth, then I'll be asking you questions. Then I'll be calling you in.
will you ask those questions as special prosecutor? How prepared are you to fall into the heavy shoes of Martin Alamichi Hamidu, given his enormous experience in the background? Many have referred to your age so far. Reading your CV, I'm encouraged that if you would be fair, firm, and courageous, we'll get somewhere. Now, it's indicated that the most veritable source of corruption globally, and particularly Ghana, is the abuse of conflict of interest. And many situations of unethical behavior is associated with persons' conflict of interest. What strategy do you have? People want to reward family and friends, want to reward other persons. Sometimes corporate entities that are formed overnight will win contracts and bid against very experienced hands in the name of conflict of interest and its abuse. What will you do as special prosecutor to give respect to the provisions of the Constitution on conflict of interest and barring public office holders from abusing that opportunity? Thank you, Chair.
Honorable Chair, there was a reference to heavy shoes of a named individual. Honorable Chair, I'd like to state that I prefer to wear my own shoes, in the sense that I am my own man and I'm coming with my own experiences and professional training. In this quest, my conscience and my learning of the law are going to be my guide. My strategy is that, Honorable Chair, I'm not naive to assume that I'm coming to stop corruption. There is no way I can stop corruption. God himself will not even acclaim to that. But I am going to make corruption very costly, very, very costly to engage in terms of conflict of interest.
Chairman, he has just said that he'll make corruption costly, high-risk activity. How do you intend to walk that road?
Exactly.
Thank you.
Honorable Chair, first, I'm going to institute what I call pressure for progress. And in this quest, there will be a systemic review of all public agencies.
What was the word you...
I said I have termed it pressure for progress.
Pressure for progress.
Yes.
Very well. I thought it was a Latin word you spoke. I didn't get it out.
I'm going to institute systemic reviews of public sector institutions and the development of integrity plans. And here, this is what I intend to do. Why can't we have our own corruption perceptions index, for instance? Why can't I rank public sector agencies against each other? And at the end of the year, publicize the results as to which institution is performing well and which institution is not performing well. In that quest, if you are head of an institution and persistently your institution is drawing the short straw in terms of the perception of corruption from the point of view of experts, from the point of view of business people, you will set up. Because
Special Prosecutor, you're aware that you are being appointed to operate a particular law. Where will you draw your authority to be publishing perception, corruption, or corruption perception index of agencies? Where under the law will you have that your authority from?
Which, the Act empowers me, if I'm given the nod by this House, to institutionalize risk assessment in respect of public agencies. And in doing risk assessment in terms of the activities of public sector agencies, it is a form of institutionalization of that systemic review of their activities. The Act also empowers me periodically, if I'm given the nod, to publish the activities of the OSP and the operations engaged in. In line with this, it is an offshoot of the mandate of the OSP that I could go ahead after the process of risk assessment, integrity of every public sector agency, to then come out with my results as to who is doing well and who is not doing well. It is an offshoot of that mandate.
Are you done with answering your question?
No, I'm not done.
Continue with that one, and other members will come in.
From the Act, Honorable Chair, 4 divisions have been created therein: finance and administration, prosecutions, investigations, asset recovery and management. I intend to create 2 more divisions to give more teeth to the OSP office if given the nod. The Act itself envisages that the OSP can create more divisions if it so desires. And I'll be adding 2 divisions. One, a strategy and research division.
Chairman, just hold it there. I'm not interjecting. Go to section 19 of your Act and make appropriate references for our purposes. You are just special prosecutor. The law assumes that you have a board. And in answering the question as Chairman posed it, the mandate is not just yours. So reference the board for our purposes, for our record. You only can create additional divisions with the concurrence of the board. Is that not legally accurate? Am I not accurate?
It is so, Honorable Chair. I believe, my apologies, but I believe I said the OSP. So when I said the OSP, it wasn't in reference to a person but the office. So the aggregate of the office, including the board. That is the context in which I placed it. Yes. May I proceed?
Very well. Yes. Honorable Gaga.
Mr. Kissi Agyebeng, congratulations. Honorable Chair, just to place on record that the Honorable Nominee actually handed over to me as legal secretary. If you go through his CV, and so I'd like to congratulate him. But having said that,
being a consideration of the OSP, would you consider yourself in a conflict situation?
Not at all, Honorable Chairman. not at all. Yes, but it's important to make that disclosure. Yes. Yes, having said that, Mr. Agyebeng, when you were nominated as special prosecutor by the Attorney General, I chanced upon an article written by a man who would be your predecessor if this committee gives you the nod. And in that article, you have been described in language that is not too palatable by the said former special prosecutor. Now, in it, he says that Mr. Kissi Agyebeng is a surrogate of a law firm. Then he goes on to further implicate you as one of the key architects of the botched Agyapa royalties transaction. Now, if you juxtapose these allegations with the role of special prosecutor as an entity that ought to be independent, you have your would-be predecessor, that is, if given the nod, describe you in such language. Honorable nominee, what is your take on this? Are you a surrogate of anybody?
Honorable Chair, I think before I go on, there's one more disclosure that I have to make in respect of Honorable Member Busa North. I was actually the chairman at his wedding reception.
Chairman was right. That he almost said that, yes, I do on your lips too.
Honorable Chair, if I may answer. Whoever says I'm a surrogate of a law firm or implicates me in the Agyapa transaction clearly does not know me. Because if you know me, you wouldn't make such allegations. And so all these things that came up, I took it as coming from uninformed positions. Because I was not involved in the Agyapa transaction in any form or manner, by any stretch of the imagination, however fertile. As for relationships, as I just disclosed, the fact that I was so close to you at some point in our lives will not give you, or you not give me a free pass because of that relationship. And that is why I'm here. And if there is a matter, I'm not going to say because I know one person or the other, I'm going to give the person a free pass. I certainly will investigate. But the truth of the matter ought to be told. I wasn't involved in the deal. I was nowhere near it. Indeed, until it started coming up, I didn't even know what it was. For the record, that is the truth. And so I'm no one surrogate. As I said earlier, I'm my own man, and I prefer to wear my own shoes. If the law firm was named, it would have even been fair to me. But if you say I'm a surrogate of a law firm, clearly you don't know me. I ran my own law firm. I've been running it since 2014 as a managing partner. I cannot be described as a surrogate of that law firm or any other law firm. Honorable Chair, that is my response.
Now, Mr. Agyebeng, you have also been described as a very young and inexperienced lawyer who is not fit for purpose. For, you know, these are descriptions that... Honorable nominee, what is your reaction to this? That you are too young and naive to be appointed to occupy a position such as the Office of Special Prosecutor. Let me ask you this. Are you experienced enough to occupy the position of special prosecutor?
Honorable Chair, first, the age. I turned 43 years on 2nd July, a few weeks ago. I qualified to be the president of this republic. I am age mates with the president of the French Republic. Indeed, you should forgive me for saying this. I'm a year older than the Minister for Justice and Attorney General. We were mates at the University of Ghana and Ghana School of Law. He is the Minister for Justice and Attorney General. There's no question about his age. Why then throw issues about my age? In terms of experience, as I stated much earlier, I was called to the bar some 18 years ago. I qualified to sit on the Supreme Court of Ghana. Indeed, I'm 3 years past the qualification for Supreme Court. I have taught criminal law, especially in the University of Ghana, for 15 years, continuously. I see, if I'm not mistaken, some of my former students around this table. Honorable member for Ejuso is my former student. Honorable member for Medina is my former student. Honorable member for Kakwe Central, I was their TA in conflict of laws. These are the products of my experience. They are here, right here, for everyone to see. And, Honorable Chair, to anchor on that, I have had a front row, although I have not been a prosecutor, properly so-called. I have had a front row to landmark prosecutions in this country. As defense counsel, I have been engaged in some very landmark cases, including the Tagore case, the Baglaskanko case. I conducted them. Honorable Chair, when Tiger IPI and Arimia announced come up with their investigative pieces, I am the one who supervises, and I've been doing this for quite a while, supervises the collation of evidence and all that for presentation to the Attorney General. Without me, the Attorney General's office will be poorer in terms of those prosecutions. So I can go on and on, but my experience is out there. And going beyond this committee to the bigger house, I think the honorable member for Old Tafu was also my former student. My experience is out there. It's on record.
Yeah, Honorable Nominee, the Office of Special Prosecutor derives its mandate directly from Article 88 of the Constitution, and that article is the one that vests the prosecutorial powers of the state in an Attorney General. Now, do you envisage a situation whereby the functions of the special prosecutor would conflict with the functions of the Attorney General, given the fact that these are functions largely derived from the constitutional powers bestowed on the Attorney General?
Initially, I would like to believe, Honorable Chair, that when this process started, you could tell that there was a clear and happy friction as to how it was going to go. And so some of us, even pointed out to the then Attorney General, informally then, actually, that, I mean, as a lecturer of criminal law, when you see some of these things, you would have to tell those in authority as to how things should properly go. There was a concern of this friction between the Attorney General and the OSP under Act 959 because of the way Article 88 has been couched. Because it gives all prosecutorial powers to the Attorney General, but then, by way of delegation, the Attorney General can delegate a person or institution to carry on prosecutions. So what the draftsman did in Act 959 is a sort of taking that discretion under Article 88 from the Attorney General, putting it in Act 959 and saying that the OSP can prosecute on the authority of the Attorney General. It is stated in the Act. And so by that formulation, from the onset in the Act, the OSP already has the authority of the Attorney General because Parliament has said so. But that would not end the story if more delineation is not done. So it appears tenuously, but the draftsman also tried to do something in Act 959 by specifying the offenses the OSP can investigate, can initiate, and conduct prosecutions in respect of. That is corruption and corruption-related offenses. There is a problematic one, the last one, which says existent offenses in relation to corruption and corruption-related offenses. It's problematic because if it is not well thought through, then a lot of friction could arise there. The reason is simple. There are two main forms of offenses that may arise in this regard. One, we have what we call predicate offenses. With predicate offenses, these are offenses which form component parts of a bigger offense. And so if the OSP is prosecuting an offense, but its component is not clearly delineated in the Act, in Act 959, and it is in the province of the Attorney General, some friction may arise there. And then the other form of offenses I would refer to as antecedent offenses. Let me give an example of the first one, the predicate offenses. For instance, corruption as an offense could have a predicate offense like money laundering. But money laundering is not specifically stated in Act 959. So the OSP can then go to the umbrella and say, okay, these are existent offenses that arise or are consequent upon corruption. There, the Attorney General could also say, look, money laundering is my province and not yours. That is what I mean. Then in respect of the antecedent offenses, these are offenses that are committed before a major offense itself is committed. For instance, if we take the offense of dishonest receiving under Act 29, something must have occurred before someone receives or disposes of property. That is to say, if you are dishonestly receiving, you are dishonestly receiving property that is the proceeds of a crime. It means a crime must have already been committed in respect of that property or funds for which you dishonestly received. If the antecedent offense has not been committed, you do not come in charging someone with dishonestly receiving. And in respect of the antecedent offenses, problems of friction could also arise in respect of the Attorney General. But I see the draftsman also tried to do something under Act 959. He said, the OSP, within 30 days after the end of a proceedings should inform the Attorney General as to the case, its outcome, and all. But I think this can be solved by properly defining, in my opinion, the jurisdiction of the OSP. And here I would advocate that we should start thinking about, Honorable Chair, if I'm not being overbearing, the passage of a Corrupt Practices Act, which will capture all these things, spell them out properly, define them properly, and the rules will become clearer. Because I'm foreseeing that in the future, serious friction may arise in respect of these umbrella offenses if the thought process is not clearly deliberated on. That's my response, Honorable Chair.
Yes, John Kuma. Now, students.
Thank you very much.
Their lecture questions.
Yes, thank you very much, Mr. Chairman, and let me take the privileged opportunity to congratulate my lecturer. Mr. Kissi Agyebeng was one of the favorite lecturers on campus for us as law students, and I want to congratulate you for the nomination. Those of us who know you believe in your competence and what you can deliver for this country. So just rest assured that you have our backing. I have a few questions to ask you, though. Well, this one is now fulfilling my duty as a member of parliament. So, as a defense lawyer, I mean, you have taught us criminal law. We know your inclination to defense. And you have practiced as a defense lawyer for quite a long time. And I'm happy you refer to some of the famous cases that you've been part. How well are you positioning yourself to now transition to be a prosecutor? Since if you look at your track record, your first inclination is to now look at the defenses possible in the act. Now you're supposed to be the prosecutor. How well are you now going to transition yourself to go after the actions rather than defending it?
Honorable Chair, let me take a little swipe at the honorable member. If you would remember in tutorials, I always said, be neutral, be in the middle as an arbiter. And that is how I've conducted myself all this while. Of course, when I take my defense cap and I wear it, I'm coming all out to defend my client. But then, I have switched sides so many times, as I alluded to the fact that, for instance, in the Anas cases, I am not on the defense side ever. I'm always on the prosecutorial side because I have to give the primary information to the Attorney General's office to run with it. It's like a baton. So I have had experience with that already. And because of the way I've always conducted myself in these things, it will be second nature to me in that regard. It is not new. It won't be new. And I'm ably placed to do that.
Great. Mr. Chairman, if you look at the Act 959, the act from which your powers have been defined, and if you check from Section 28, where it talks about the powers of your office, up to Section 46, it appears the same, almost the same provisions are provided in the Act 804, which is for the Economic Organized Crime Office Act 804. You are given the powers of seizure, the powers of search, the powers to freeze accounts on suspicion of corruption, among even powers of confiscation to aid your investigations. And you even have 7 days where you can seize property or power before you go to court for confirmation of your orders. All these are also provisions in the Act 804. One of the nightmares of any lawyer, a practicing lawyer in Ghana, is where you are in court with, say, Yoko, and then BNI, which is now NIB, will be waiting to pick your client on the same matter. And it appears this is exactly what we are repeating also with your role. So a lawyer's client can be invited by Yoko on accounts of corruption or tainted funds or accusations of money laundering. And even similar provisions is also found in the Financial Intelligence Act. So FIC could also invite your client. On the same provisions, the Office of Special Prosecutor is also mandated by this act to call your client. What will be your advice as a special prosecutor in instances where your powers as defined in the act conflict with the same provisions in other acts as I've referred to?
Honorable Chair, the advice has come by way of statutory provisions in the Act itself. Because Act 959, in Act 959, Parliament says there in the Act that we should cooperate. Otherwise, it will be totally duplicitous and unfair to suspects. I think the reason why the other agencies act the way they do is because they don't have the final push of prosecutorial powers, because they would have to refer their dockets to the Attorney General's department. But in this case, everything terminates with the OSP. And so, in that sense, it is a bit different and unique from the other agencies like the FIC, Yoko, NIB, and Anshraj, for instance. Yes. Since the Act itself is telling all these agencies to cooperate, that is how we need to go. Otherwise, one agency is doing something, another is also doing it. If we don't cooperate, for instance, suspects can easily walk through any crevices we will provide. They will gladly walk through because we are not cooperating, we are not comparing notes. If we cooperate and compare notes, then one agency can see its way clear to say, this falls directly within my province, and I should take it up, and the other agencies would have to let go.
Mr. Chairman, there is a raging legal debate in jurisprudence on law of evidence, on admissibility. Two schools of thought. One school says that evidence is evidence. It doesn't matter how you procured it, even if you stole it. It must be admissible. And in fact, in Ghana, some people refer to it as the Anas principle, where it does not matter even if you were deliberately set up to commit a crime. It is okay. That's one school of thought. Another school of thought questions the legality and the process of procuring such evidence and describe it sometimes as a blackmail or unconstitutional on the rights of the accused persons. These scenarios exist in different countries. In America, for instance, they don't accept the first scenario in case versus Ohio. In India, several lines of cases reject illegally acquired evidence. But when you come to our jurisdiction, and most of the Commonwealth common law jurisdictions, our laws are not clearly defined on whether illegally acquired evidence must be admissible in our courts. As our special prosecutor, and especially with your background in your private practice, with more associated with the Anas principle, in a democratic environment as we have in Ghana, now that you are going to be the Office of Special Prosecutor, how are you going to marry these two schools of thought to ensure that constitutional rights of even accused persons are respected and fairness prevail even in such circumstances?
Honorable Chair, foremost, the Anas principle is not akin to illegally acquiring evidence. It's a different matter. But since time immemorial, Honorable Chair, I agree with the Honorable Member, this debate has been raging. But in recent times, I do believe that our Supreme Court has sought to bring some harmony in respect of these two competing theories that are fighting for mastery. And it has placed it in a more clear contest in terms of what will be acceptable and not what will not be acceptable. So the general rule will then be that, from my reading of all these decisions, the general rule will then be that, and that is how I'm going to go anyway, that if I'm giving the nod, that ordinarily, that's the general, ordinarily, evidence illegally procured will not go in. But then there are accepting circumstances. It depends on the exigency of the matter and the seriousness of the occasion. For instance, if we were to see someone committing blue murder right in front of our eyes and we videoed him, like what happened with the infamous George Floyd case, are we going to say when the video was being taken of those officers because it wasn't with their consent, the court should not accept the evidence because their privacy was being breached? In that situation, a life was being taken, and it trumps the person's right to privacy, the person who is committing the crime. It trumps his right to privacy. So all said and done, we situate it in the context of a balance. How do you weigh it? That is how we're going to go. How do you weigh it? And if the evidence trumps the rights of the perpetrator, it should be accepted.
Well, Mr. Chairman, just a follow-up question.
No, you're done. Yes, yeah. Thank you very much. Mr. Kissi, on your nomination, let me congratulate you. In your earlier responses, you touched on the relationship between the Attorney General's office and the Office of the Special Prosecutor. I see in the enactment of Act 959 that we try to provide some sort of veiled amendment of Article 88 of the Constitution, using specifically 88.4. That says that all offenses prosecuted in the name of the Republic of Ghana shall be at the suit of the Attorney General or any other person authorized by him in accordance with any law. So I assume that the amendment or the passage of this act is hiding under the phrase in accordance with any law. But can you, given your experience as a criminal law lecturer, and I believe being a law lecturer, you do remember your constitutional law also. Can you tell me what you think about Article 88.3 itself? 88.3 itself, which says that the Attorney General shall be responsible for the initiation and conduct of all prosecutions of criminal offenses. Is that the clause that we ought to have been amending?
Honorable Chair, as I stated earlier, it is clearly problematic constitutionally. And as I said, some of us expressed our views informally to the then Attorney General as to the constitutionality of the creation of the OSP. And Article 883, as you have identified, is the mother of this problem. And what Parliament has done is it tries to then marry with this provisions in Act 959. It tries to marry in a sort of sidewind fashion 883 and 884 by just giving the authority of the Attorney General, whether he likes it or not, in that sense, if I may be obtuse, to the OSP. So, to prevent this situation where the OSP will then be always going to the Attorney General to seek his or her authority to initiate and conduct proceedings. And that is why I said that it appears then when the draftsman saw the mischief, that he hadn't really solved the mischief. He then at the back said, okay, when you finish, tell the Attorney General what you have done. There's still more work to be done. There's still more work to be done on this.
Work to be done by who? Parliament or you?
Honorable Chair, it has to be Parliament with my input and help when I'm giving the nod that we need to clean house properly to make things clearer. As I kept saying earlier, that friction may arise one day. Friction may arise one day if, for instance, the sitting Attorney General and the sitting OSP do not see eye to eye really on a certain matter. Serious problems may arise. Honorable Chair, I agree with you. It should have been, if they may forgive me, better thought through. But with what we have, it is food that is still edible. Maybe we can garnish it later, but we can still eat what we have now.
Chairman, which food? This one with salt or without salt?
Honorable Chair, being a Kwauman, it can only be fufu and cracker.
Chairman, if the Honorable Ayaga will accommodate me. So, lecturer, conflict of laws. What conflict have you seen between a constitutional provision and an act of parliament? Where should the hierarchy of respect be, in your view? And what should we do the way forward? I like your thinking on this matter, but go further. What should we be doing in order to realign the provisions of the Office of the Special Prosecutor Act consistent with Article 88 of the 1992 Constitution? Thank you, Chair.
Honorable Chair, of course, every law student knows that the Constitution takes precedence. But what should we do? I think I've intimated to it. The mother problem is 88.3. That is where the issue appears to be. And so, if we are able to amend 88 in such a way as to lessen its mandatory language in that context, to allow other agencies to perform such a function, because in practice, I would like to believe from my experience that Attorney General's office is already inundated. And so these satellite agencies will need to augment.
Chairman, just a little clarity. So are you for a constitutional amendment to Article 88, or to quote your words, cleaning up the OSP Act? Where do you stand? Are you advocating for review and amendment of Article 88 or specific to the Act? Thank you, Chair.
Honorable Chair, I'm not just limiting my sights to the OSP. I was also transferring it to other agencies like the FIC, the IOCO, and all that. So all these acts, together with Article 88, must be thought out again and clean house.
Yeah, okay. So related to that and the federal house cleaning exercise that we may need to do, from your reading of the Constitution and then Act 959, do you foresee a situation where one will say that the mandate that is given to the special prosecutor is actually not exclusive, and that any time the Attorney General's office can take on any case that has to do with corruption, and also to whatever the Office of Special Prosecutor is doing, also prosecute those cases, that we haven't really given an exclusive mandate to the Special Prosecutor?
Honorable Chair, the attempt was made, but the job wasn't finished. And it's because, once again, you had the problem of Article 88.3. It was difficult to go around Article 88.3 to exclude the Attorney General from it. And I would say Attorney General shouldn't be excluded from any criminal proceeding in that sense. Because of the way Article 88 has been couched, it was impossible then in 959, when the mandate of the OSP was being spelled out, to then say that the OSP has exclusive jurisdiction in respect of corruption and corruption-related offenses, and no one can come close. It was just impossible to do that because of Article 88. But with experience, Attorney General should always have an interest in terms of what is going on in respect of the conduct of criminal proceedings, investigation of criminal proceedings, initiation of criminal proceedings. Because at the end of the day, he is justice. Attorney General is justice. Everything any other agency does. In truth, the OSP is specialized, and it has a more focused approach to things. But whatever any agency does, it is to justice. And being Minister for Justice and Attorney General, that office should not be expressly excluded from criminal proceedings, conduct of criminal proceedings in that regard. So I won't go that far, but I will say we need to, once again, repeating myself, clean these things up in the general scheme of affairs to make things more clearer.
I think this is my last question. Yeah. So my last question relates to a function of the OSP that I don't think conflicts with the constitutional provisions relating to the Attorney General, and that has to do with fighting corruption. I think the issues with the Attorney General has to do with initiation of criminal proceedings. But before initiation of criminal proceedings, every other function, we can legislate that anybody can do that. So in the area of fighting corruption, what do you think you can do? You've just mentioned corruption perception index ranking of public agencies. I think that under Section 2C, you are to take steps to prevent corruption. Naming and shaming can't prevent people from engaging in their conduct. So I think that you are well grounded in Section 2C if you do perception index ranking of public utilities, public agencies and institutions. Beyond that, what new ideas do you have in terms of your functions under 2C, the objects of the office, to take steps to prevent corruption?
Honorable Chair, I think it should be obvious to everyone that we cannot fight corruption solely through the criminal law. It is also because we live in a society of ritualistic gift-giving. If you happen to have the unfortunate situation, just by way of illustration, unfortunate situation of having your back wheel land in a gutter, and someone comes to help you out, the person is expectant that you will give him something. this society is, this is what we thrive on. It is a ritualistic gift-giving society.
I'm saying that it's not just your vehicle landing in the gutter, but in the case of MPs, even if he greets you, he expects a gift.
You see where the problem lies. And because of that, it is very difficult to distinguish the acceptable from the unacceptable. And this is what is informing my drive if given the nod. That if I were to just focus on the criminal law aspects, that is to say, prosecution, I won't go far.
Quickly, do you have any agenda in relation to election campaign financing? I'm trying to focus the question. Trying to focus the question.
Thank you. You're done. Now, Obiamo first. Yes.
Thank you, Mr. Chairman. Congratulations, Honorable Kissi Agyebeng. You are famously known to be a very good criminal law lecturer and also a practitioner as far as criminal law is concerned. Now, we seem to have spent some time on the mandate of the office. Going back to the Act 959, specifically Section 4, where the mandate of the office is spelled out. And as you seem to allude, if the ordinary man wants you to explain to him what you are required to do as a special prosecutor, how would you put it? Especially where the impression has been created that your office is more or less not required or necessary, given that you fall under Article 88. I'm asking this specifically because of Section 4, because the impression is created that you fall under only 4.2. Well, if you look at even 4.3, it will expand your mandate. And probably we may not say that this office is not too necessary because of Article 88. Yes.
Honorable Chair, interestingly, when my name came up, my own kids were asking me, so Daddy, what is it that you're going to do if you're given the nod? In simple terms, the office is to investigate, prevent, prosecute for corruption, and manage seized, frozen, or confiscated property. But, Honorable Chair, in terms of the relevance of this office, the day we scrap this office is the day we say goodbye to our fight against corruption. Its relevance is borne out by its attributes and its uniqueness. It is unique as compared to all the other law enforcement agencies in respect of its mandate, because no other institution has been carefully thought out and designed to fight corruption specifically as Act 959 has done. And, Honorable Chair, in respect of this, the Office of the Special Prosecutor is the gold standard under the UN Convention Against Corruption and the African Union Convention on the Preventing and Combating of Corruption. The international community, including Ghana, we ratified these conventions way back in the early 2000s, I think 2002 if I'm not wrong, that every jurisdiction requires such a specialized agency We should be made independent with a specialized trained staff to focus on the fight against corruption. Now, the, if I may say, flaw with Article 88 in terms of the Attorney General is that we sometimes require too much of individuals occupying the office of the Attorney General. Come to think of it, the Attorney General is a member of cabinet. He is part of the government. How independent would he be in terms of certain individuals if they were to fall foul of the law, if, for instance, they are also members of cabinet or members of the government? But in respect of the OSP, an agency, a person manning it, who is not part of the government machinery, who is independent, and Honorable Chair, giving the nod, I'm going to guard my independence.